Welcome to the Deep Dive. We're continuing our educational series looking closely at the Manual of Patent Examining Procedure, the MPEP.
Yep, breaking it down section by section.
Our goal is really to make U.S. patent law more accessible, maybe especially if you're studying for the patent bar exam or, just want to get a better handle on things.
And today we're tackling a really important one, MPEP, section 2142.
Section 2142, what's the title on that one?
It's called Legal Concept of Prima Facie Obviousness, and it sits right in chapter 2100, which is all about patentability.
Okay, patentability. And prima facie obviousness, that sounds foundational.
It absolutely is. Section 2142 basically outlines the rules of engagement, the legal structure for how examiners and applicants deal with obviousness under the law, under 35 U.S.C. section 103.
Obviousness. It always sounds simpler than it is in practice, right? So this prima facie aspects, what does that really mean in this context? Is it like a first step?
Exactly. Think of prima facie obviousness as a structured way to handle who needs to prove what. It's all about shifting the burden of proof.
Okay, burden of proof. How does that work here? Who starts?
Well, the initial burden falls squarely on the patent examiner. They have to be the ones to first establish what's called a prima facie case of obviousness.
Meaning they can't just feel it's obvious. They need to build a case.
Precisely. And crucially, that case must be backed up by factual evidence. They need support for their argument.
And where does that evidence typically come from?
It comes from the prior art. So things like existing patents, published applications, journal articles, really any publication out there before the relevant date.
Gotcha. They need to point to something specific in the prior art that suggests the invention wasn't really a big inventive leap.
Right. They're essentially saying, based on this prior art, here's why we think this claimed invention would have been obvious.
Okay, so the examiner puts forward this prima facie case, backed by prior art. What happens then? Does the ball shift courts?
It does. Once the examiner establishes that prima facie case, the burden shifts right over to you, the applicant.
So now it's the applicant's turn to respond.
Yes. It's your chance to rebut the examiner's case. You need to provide arguments or evidence showing why, despite the cited prior art, your invention is actually not obvious.
And what kind of rebuttals work? What can an applicant bring to the table?
There's several ways. You could show comparative test data, demonstrating your invention performs way better than the prior art would suggest.
Like superior results.
Exactly. Or you could demonstrate unexpected results, maybe a surprising synergy or a property nobody would have predicted.
Okay. What else?
Expert declarations can be powerful, getting someone skilled in the field to explain why it wouldn't have been obvious.
An expert opinion. Makes sense.
And sometimes you can argue directly against the examiner's interpretation of the prior art itself, maybe point out differences they missed, or argue that their proposed combination of references just wouldn't make sense to someone in the field.
So, multiple angles for the applicant to push back. Let's go back to the examiner's initial job, though. You said they need a clear rationale. What does that involve? It sounds specific.
It is. MPEP, section 2142, lays out 4 specific things the examiner must include in their reasoning. They can't just make a conclusory statement.
Okay, 4 key components. What are they?
First, they need to identify the relevant teachings in the prior art they're citing. What specifically in those documents supports their argument?
Right. Point to the exact parts. Number 2.
Second, they have to clearly spell out the differences between what you've claimed in your application and what's actually in that prior art.
A clear comparison. Okay, third.
Third, if they're combining references, they need to explain the proposed modification. How would these pieces logically fit together?
Makes sense. And the last one.
And finally, this is maybe the most crucial part. They must provide a reason why a person of ordinary skill in the art, the posita, would have found the invention obvious at the time.
The posita, that hypothetical person. So the examiner has to explain the motivation for that person to arrive at the invention.
Exactly. Why would that ordinarily skilled person, looking at the available prior art, have been led to make that combination or modification? And it has to be objective reasoning.
Objective, meaning based on evidence available back then.
Yes, based on what was known before the invention. For AIA applications, that's generally before the effective filing date. For older pre-AIA ones, it's before the date of invention.
And crucially, no hindsight, right? They can't use the invention itself as a roadmap.
Absolutely critical. Hindsight is a big no-no. The analysis has to be grounded purely in the prior art context.
You mentioned court cases earlier. In Recon and KSR v. Teleflex, how do they play into this?
They really reinforce this need for explicit reasoning. Both cases, especially KSR, emphasize that the examiner can't just make bald assertions.
So KSR didn't just make everything obvious.
No, while KSR allowed for more flexibility and common sense in combining references, it absolutely did not remove the requirement for the examiner to articulate a clear, logical reason why the combination would have been obvious to the posita. Mere conclusory statements are still insufficient.
Okay, so the why is still paramount.
The why is everything. Let's use an example. Say the examiner cites reference A for feature X and reference B for feature Y. Your invention combines X and Y.
Okay.
The examiner can't just say X existed, Y existed, combining them is obvious. They need to explain why the posita would have seen a reason or motivation in the prior art to put X and Y together in that way.
Maybe reference B solves a problem that reference A has, or something like that.
Exactly. There needs to be some kind of suggestion or motivation, either explicit or implicit, in the prior art.
And then what if the applicant comes back with data showing that combining X and Y produces this amazing, unexpected synergistic effect?
Well, that's strong rebuttal evidence. The examiner must consider it objectively. They can't just brush it aside because they already made their initial case.
So the final decision isn't just based on the examiner's first shot.
Not at all. The final decision has to be based on the entirety of the record, the examiner's case, and the applicant's rebuttal. It's weighed using the standard of a preponderance of the evidence.
Preponderance of the evidence. Meaning, is it more likely than not that it was obvious, considering everything?
That's the standard, yes.
This really underscores how important the written communication is, like the office actions.
It's absolutely essential. A well-reasoned rejection, laying out those 4 points clearly, does two things. First, it tells you, the applicant, exactly what you need to address.
Gives you a clear target for your response.
Right. And second, it builds a clear prosecution history file. This record is incredibly important if the patent ever ends up in court.
Because it shows the reasoning behind why claims were allowed or rejected?
Precisely. It helps interpret the scope of the claims later on. And remember, examiners generally don't testify about their thought process.
So the written record is basically it.
The written record is the explanation. In cases like Inri Pititeki and Armia Rudiker drive this home, they state that rebuttal evidence has to be considered alongside the initial rejection, not just weighed against it separately. The final decision has to reflect that combined evaluation.
So it's a holistic view in the end. The examiner has to integrate the rebuttal into their analysis.
Exactly. The whole process aims for a fair, legally sound decision based on all the evidence presented.
This has been incredibly helpful in understanding MPEP Section 2142. It's much more structured than just saying something looks obvious.
It really is. It's a core part of ensuring patent quality and fairness in the examination process.
And we should definitely give a shout out here. This deep dive, and actually this whole series, wouldn't be possible without the coordination and vision of Mike Shepard.
Absolutely. As creative director, his leadership has been key in turning this complex legal stuff into something hopefully much more digestible for everyone learning about patent law.
Agreed. And of course, the necessary disclaimer.
Right. Just a reminder for you listening, this summary used AI tools in its creation, and it might have errors. It's purely for educational info.
It's not legal advice. Always check the official MPEP itself, or talk to a qualified instructor or a registered patent practitioner for real guidance.
Definitely. Official sources are paramount.
So, wrapping up, grasping this concept of prima facie obviousness is clearly vital for navigating patent prosecution. That whole burden-shifting mechanism really defines the interaction.
It shapes the entire dialogue between the examiner and the applicant.
And maybe a final thought to leave you with. How might digging deeper into who that posita, that person of ordinary skill in the art, actually is in a specific technical field? How might that affect the strategies you use to counter an obviousness rejection?
That's a great question. Understanding the mindset and knowledge base of the posita is often key to crafting successful arguments.
Definitely something to chew on. We really encourage you to keep exploring the MPEP. There's always more to learn about U.S. patent law. Thanks for joining us on this deep dive.